Mary Bauer has directed the Immigrant Justice Project of the Southern Poverty Law Center, a program designed to protect immigrant workers in the southeast United States since its inception in 2004. Ms. Bauer is a graduate of the College of William & Mary and received her law degree from the University of Virginia.
Thank you, Mr. Chairman and members of the committee, for inviting me to speak today. My employer, the Southern Poverty Law Center, recently published a report entitled Close to Slavery, based upon interviews with thousands of guest workers, and that report was about the H-2 guest worker programs in the United States. The H-2 program in the U.S. has led to the creation of a quasi-criminal army of recruiters in Mexico, Guatemala, and other countries to locate and hire H-2 workers for employ in the U.S. It has also led to the systematic exploitation of workers once they arrive in the U.S. H-2 workers can work only for the employer who files a petition for them to enter the country. The employer decides if he can come, the employer decides how long he can stay, and the employer holds all of the power over the most important aspects of the worker's life. Fear of retaliation under this system is a recurring theme of a worker's life. When recruited to work in their home countries, workers are often forced to borrow enormous sums of money, up to $20,000, borrowed at high interest rates, to obtain the right to be employed at a temporary low-wage job in the U.S. Many workers have been required to leave collateral, often the deed to their home, in exchange for a chance to come to the United States to obtain an H-2 visa. Once in the U.S., guest workers routinely receive less pay than the law allows, even far less than the minimum wage. In some industries that rely upon guest workers for the bulk of their workforce, wage and hour violations are the norm rather than the exception. Workers report to us time and time again that they have been lied to at the time of recruitment. They arrive in the U.S. to find that things are not as they expected, but by then they are deeply in debt and without options. Guest worker programs also permit the systematic discrimination of workers based on age, gender, and national origin. Under this system, workers simply lack the ability to combat exploitation. The DOL conducts very few investigations of H-2 employers, and workers have little realistic opportunity or chance of enforcing rights on their own. The DOL contends that it even lacks the authority to enforce the rights of H-2B workers to receive sufficient work or to receive the prevailing wage that is theoretically due to the workers. None of the significant protections that exist, at least on paper, for H-2A workers have even been adopted relative to H-2B non-agricultural workers, as DOL has never promulgated substantive labor protections for those workers. There's no requirement for transportation, no requirement for free housing in the H-2B context, no requirement that the housing provided be decent. And when they are abused on the job, H-2B workers are not even eligible for legal services. Congress should pass the protections of Chairman Miller's bill. This bill would make clear that the systematic discrimination entrenched in this program is illegal. It would regulate recruitment costs, and it would make employers responsible for the actions of the recruiters that they choose. It is an important first step in the reform of these programs. Congress should also make H-2B workers eligible for federally funded legal services. There's simply no reason that these workers who have come to the U.S. under the auspices of a government-sponsored program should be excluded from eligibility. I would suggest that Congress should hold further hearings on the issue related to the administration of guest worker programs. In particular, Congress should ask the Department of Labor what actions it is taking to protect workers and similarly situated U.S. workers on the job. Why are there so few inspections? Why are there no substantive labor protections for H-2B workers? In conclusion, the abuses of these programs are simply too common to blame on a few bad apple employers. They are the foreseeable outcomes of a system that treats foreign workers as commodities to be imported as needed without affording them adequate legal safeguards. I thank you for this opportunity, and I await any questions you might have.